We're seeing some big lawsuits on some big topics work their way through the court system external to the Ninth Circuit. CRPA is getting those amicus briefs out to support these cases. Let's talk about it. Hey everybody, welcome back to the channel today. That's right, some more amicus briefs have been filed to supplement some litigation that's going on around the nation. To walk us through that, we have brought back friend to the show. He's an attorney at Michelle & Associates. You find his name on a lot of this litigation, and that is Kostas Moros. Kostas, thanks for being with us today.
Evan, always a pleasure. Happy to be on.
Thank you, and absolutely. But before we get into that today, guys, please be sure to like, share, and subscribe to these videos. It really helps with the algorithms to get this message out there. And of course, at the end of the day, we're looking to educate as many people as we can on this litigation so that we can progress the Second Amendment movement forward. And also, don't forget, we are just a couple days from the general election. That is November 5th. If you haven't voted yet, go ahead and check out on CRPA.org. We've got the voter guides there in case you were wondering who is for and against the Second Amendment. They've got their grades there. We've also got our endorsements. And of course, we've got the election live stream coming up. Rick and I will be in studio from 6 to 10 p.m. to give a Second Amendment focus on these elections that are happening. Obviously, we're going to be covering the presidential elections. We think it's important to cover the California elections as well. So, Kostas, jumping into this really quick, before we even get into these couple of amicus briefs that I wanted to touch on, could you go ahead and just remind us what exactly is an amicus brief and what would be the incentive for CRPA to file amicus briefs?
Okay, so an amicus brief literally means, I forget if it's a Latin word, but it literally means friend of the court. So what it usually entails is a party or other group or outside group or individuals, sometimes professors, write a brief with their opinion on the case and either urge the court to rule for one side or another, or sometimes neither side. They'll argue, we're not really taking a side, but this is our perspective, and you should keep this in mind when you decide the case. And they don't have to stick to even legal issues. For example, in the Rahimi case last year, a lot of the amicus briefs were about history or were about statistics on domestic violence. They can just inform the court. They can go way outside the bounds of what the parties can focus on and talk about all sorts of extraneous issues that they want the Supreme Court or lower courts to keep in mind. And the interest here is that, a lot of times we at CRPA, I like to joke that we have to play the game in hard mode because we're in the Ninth Circuit, right? So we always have to deal with these often hostile judges that are not favorable to the Second Amendment. So what an amicus allows us to do is argue our perspective to other courts. For example, if there's a Fifth Circuit case, like we recently did an amicus brief on the Gun-Free School Zones Act in the Fifth Circuit. And if we were to persuade a Fifth Circuit panel, which is a generally more favorable court, to rule in favor of the gun rights side, we can then take that Fifth Circuit opinion and use it as persuasive authority in the Ninth Circuit. Or even if the Ninth Circuit isn't persuaded by it, should we ever have a case like that here or on any other topic, and there's a circuit split, it makes the Supreme Court much more likely to take the case if the circuits disagree. So there's a lot of reason you want to be filing amicus briefs. It just comes down to an issue of resource and time limitation. So we tend to do them more when things are a bit slower in our cases, like right now with the Duncan logjam, or and when resources allow, because it's not, of course, free to have lawyers write briefs, but we have been churning out a lot of them lately.
Yeah, and I guess it's just, I don't know if you want to categorize it as a game that's played, but it just sort of is part of the system, not only an incentive to help a Second Amendment case somewhere else, but like you said, get the payoff on the back end, whether it's creating precedent or using something persuasive in our own cases here. Well, having said that, let's jump into one of these amicus briefs that we've filed more recently. I wanted to get your thoughts on the Snope v. Brown litigation. I know we mentioned it on the live stream last weekend. For those who didn't catch that, can you go ahead and give us a rundown of what this Snope v. Brown case is, as well as the context of CRPA's amicus in it?
Sure. So Snope v. Brown was formerly called Bianchi v. Frosch and then Bianchi v. Brown. So I know some of our listeners may recall that one, even if they don't recall Snope. So Bianchi went up to it's a challenge to Maryland's assault weapons law. So that's Maryland's similar law to what California has, where it bans common rifles like AR-15s and such. I can't recall if it has the similar features. Here we can get around it with a fin grip and such. I'm not the expert on Maryland's particular law, but I think it is similar. So the case has been it's been going on for years, and it, along with Duncan and a couple other cases, was remanded by the Supreme Court after Bruin. So it was held by the Supreme Court and then remanded. It went back down. The appeals court took a year with it, only for the en banc court to take the case back in the Fourth Circuit, and which was a little, frankly, corrupt how it went about that. But at least they got the ruling out fast. I'll give them that. So they didn't stall. They got it out pretty fast, because it was heard around the same time as Duncan, but we're still waiting on Duncan, whereas this opinion came out in August. So Snope now is on petition for review in the Supreme Court, and we're very, very hopeful that the Supreme Court will grant review to this case and decide once and for all the quote-unquote assault weapon ban issue. Now, of course, this doesn't include magazines, so that would still be an open question unless the court decides to go expansive in its language. But we could at least settle one big question here and provide a lot of relief for a lot of people across the country, including in California. So we thought this was an important one to write an amicus brief urging the Supreme Court why it needs to grant cert in this case.
And is that what it was then? The amicus brief that CRPA put in was an argument that the Supreme Court needed to grant cert for the case?
So this is unique with the Supreme Court. Like I said, you can do amicus briefs at every level, sometimes even district courts, although district courts, I think you need are a little, you need to get permission from the court usually to do that. But appeals court, Supreme Court. But with the Supreme Court, what's different is that you can write two, actually. There's one on the petition stage. So when a petition is filed, you can write an amicus brief urging the Supreme Court, or on the other end, telling them not to take a case. So you can argue both sides of that. And then if they decide to grant cert, you could do another one, which we would. You could do another brief arguing the actual merits of the case. So the first brief is, this is why you should take it. This is the questions that need to be answered. And the second brief is arguing the actual case if they decide to review it.
Well, this is certain. I mean, that certainly is one of those big topics when you come to the political conversation. You've got a lot of definitions and terms that have been altered and made up over time. The assault weapon, a term is extremely politically charged. I guess, we're going to hope that the Supreme Court takes that case. We get a good ruling and hope, they do that swiftly as they have been. Kind of running parallel to that, external from the Ninth Circuit, we've seen the U.S. versus Ayala litigation. Looks like we filed an amicus brief for that. This one, if I understand, came out of New York. You had a post office worker who had a CCW who went to work with the firearm on him, and similar to the May v. Bonta case, they have sensitive places over there. He ends up getting prosecuted for that. We filed an amicus brief here. I wanted to read a quote because our answer to this seemed to be pretty blunt from the introduction. Jacob, if you can pull it up here, it reads like this. Yet not one law was enacted that banned firearm possession in the post office by members of the public until late 20th century. As to the peaceable carry of firearms to self-defense, that should be the end of the matter under the Bruin analysis, as the only relevant historical tradition pertains to banning firearms in places where the deliberative business of government is conducted. Can you give us a rundown of this case, and then also kind of explain what the CRPA amicus brief was getting at here?
Sure. So one correction, it's not in New York, it's actually in Florida. And what it concerns is a violation of federal law, because since I think the 70s, there's been a law that you can't carry in government buildings, federal government buildings, which has been construed to also include post offices. And so what happened here was that a postal employee, not one that usually works in the office, but a truck driver for the Postal Service, was carrying, and he got caught when he was just stopping at a post office. So he has a Florida CCW permit, and he's otherwise, law-abiding citizen, no record or anything like that, but he got caught carrying, and now he's being criminally prosecuted for it. So what we want, especially because, so two things attractive to us in this case. Let me back up. First of all, it's in the 11th Circuit, which is a very good circuit for us. There's no guarantees ever. You could still draw a bad panel, but this is a great opportunity for us to have a sensitive places case in front of a good panel. And the reason this rarely happens is because circuits like the 11th Circuit, the 5th Circuit, they don't hear as many of these sensitive places because none of the states in them pass those laws. So it's actually great to have this chance to have a good circuit talk about sensitive places, and then we could use that here in the 9th Circuit in our own cases. So anyways, we filed an amicus brief making a number of arguments. We first of all explain how the historical analysis should work under Bruin. That's elementary though. But then we go into talking about how the law here just doesn't fit with the historical tradition. And that's because, the founders might not have been able to imagine a lot of things, but the Postal Service was actually in the Constitution. This is one thing they definitely could have imagined. And we talk about this history of postal employees actually being armed in the 19th century, and even in the 1960s when there was a surge of crime against postal workers and robbing them. The Postal Service in certain areas actually issued 38 caliber revolvers to a lot of its employees to defend themselves. So there's just no historical tradition of banning carry in post offices by anyone, let alone a confirmed law-abiding postal employee. If they want to, and look, if the Postal Service wants to punish its employees or even fire them for carrying at work, they're allowed to do that like any other employer is. But they are not, that's not what's at issue here. And that's actually what the government argues. Well, he's an employee, we can do what we want. But they're criminally prosecuting him. Fire him if you want. I think that's not a nice move at all, and they shouldn't. But clearly he shouldn't be criminally prosecuted. This law has no standing in history. It has nothing to back it. So we hope that the court will agree with us. And the lower court, by the way, did side with the plaintiff. So we're looking for the 11th Circuit to affirm the district court.
And good catch there. When we're talking about Second Amendment litigation, it's always too easy to talk about California, Illinois, and New York. So thanks for correcting me there. This one is coming out of Florida. So I mean, you kind of already alluded to it when you were describing what amicus briefs are, but specifically for this one, similar to what you already said, are we looking for some precedent in the May v. Bonta case? Is there any way here that Ayala ends up affecting May v. Bonta?
Oh, sure. And look, the circuits don't have to listen to each other. For example, if the 11th Circuit issues a very favorable ruling and we get some great language, the 9th Circuit might say, we don't care, but it's always great to be able to cite what other circuits are saying. And like I said earlier, even if the 9th Circuit continues to disagree, then we might have what's called a circuit split. And that makes a case far more enticing to the Supreme Court. They're much less, Bruin didn't have a circuit split and they still take it. So they do still take cases when the circuits agree, but the odds of getting cert granted are way higher because the Supreme Court does not like it when one circuit says, for example, you can carry in a post office and another interprets the same federal law to say the opposite. There needs to be consistency in the law. So that's the first thing they typically look to do when they grant cert. So that's why we hope to create some chaos, with the good circuits by having them rule against these sensitive places while, the typical 9th, 2nd Circuit, all the bad circuit, the anti-gun circuits will continue to uphold those laws. So we need to get some splits going.
Well, certainly some more lawsuits to follow along with. CRPA has contributed to them with these amicus briefs, and we'll see if these end up getting good decisions or getting to SCOTUS. I guess, Kostas, to cap this off here, you stated, and it's true, like we're on hard mode here in the 9th Circuit. What's your overall view, other than the 9th Circuit, of some of this litigation at the federal level?
My overall view, well, right now, my overall view is the Supreme Court needs to start granting some of these cases and deciding these issues. I think that we're in this pattern now where I'm not saying Bruin didn't help the bad circuits. Like, for example, you can't say it hasn't helped us in California. Now, although there's still issues with slow, long wait times and high fees, people are now carrying in these cities. People can buy modern handguns thanks to Bolin v. Bonta. So things are changing. But it is true that what we're seeing now is that if you live in places like the 5th Circuit, the 11th Circuit, and the states within them, and a couple others, you have far more expansive Second Amendment rights than people in the 9th Circuit or 2nd Circuit. So the only way that's going to be resolved is if the Supreme Court starts granting certainties on these cases, and they can start with Snope, and I hope they do start with Snope. But I think something that might give the Supreme Court courage is a good election result on Tuesday. I imagine that if the election does not go our way, they will be a little bit more timid in what they do, lest they're afraid of court packing or something like that. So I realize there's a lot of issues people vote for, and I don't begrudge that, guns aren't the only issue for everyone. But if you do vote based on to the extent you vote based on your Second Amendment right, I think the choice on Tuesday is very clear. So.
Clear indeed, and a lot to look forward to, which is why we're giving a push to some of these cases like Snope, getting those amicus briefs in there. Kostas, I know you're a busy guy, got a lot working on. There's a lot that you're working on there. I appreciate you taking the time to be with us here today.
Thanks, Kevin. Have a good one. Thank you.
Absolutely, you too. And guys, if you like videos like this and you want to continue to stay informed, please be sure to like, share, and subscribe to the channel. Hit that notification bell so that you get notified as these videos come out. And hey, once you go out and vote on November 5th, go home and turn on CRPA TV. We're going to be live streaming the election from 6 p.m. to 10 p.m. Like I said, we are going to be covering the presidential elections, but we're also going to have that Second Amendment lens here on the California elections as well. Hope to see you guys there. Thanks, and have a good one.